Litigation Reforms and Other Litigation Themes, presented by Michael Farley from the Ohio Insurance Institute. I am Sue Quimby, Senior Vice President of MSO Inc. Joining me as hosts are MSO CEO President Jan Seitz, Assistant Vice President, Senior Product Analyst Mary Beagle. Also joining me for technical support is Cassidy Cody, Product Development Analyst from the hurricane path in Florida. Please take a minute to note the antitrust statement. We will not discuss or answer questions that might address any trade secrets. Next is the disclaimer. Copies of these items are available upon request if you can't sleep at night and want something to read. We would like to thank our generous sponsors listed on the screen and our website. They help us provide these quality educational webinars, ed seminar, and golf outing. Annual and event sponsorship opportunities are available. In fact, the annual sponsorship mailings have gone out recently. Contact us for information. MSO is pleased to offer at least 8 webinars each year. We welcome suggestions for presenters and topics for our webinars. We're hoping to offer CE for more of these. In fact, we're planning to offer only three webinars next year, but having CE for each of them. If you missed any previous webinars, they are available for on-demand viewing on our website, msonet.com. They will also be available on our new YouTube channel at the Mutual Service Office. Please subscribe to the channel. It's free. Cassidy will list the website, YouTube, and LinkedIn addresses in the chat. This year's Ed Seminar will be held on November 12th and 13th. 2 one-hour sessions will be held each day. Topics are agritourism, claims trends, artificial intelligence, and ensuring your online business. The Ed Seminars are free to all. As part of our nationwide school expansion, CE credits will be filed in multiple states upon request. You may have seen our training flyer. We offer CE and non-CE training for member companies, agents, and other industry members. In 2024, our goal is to be licensed as a school in 50 states. We are currently at 32. Contact us for more information. Now about our webinar. This presentation will discuss implications of third-party litigation funding, efforts to reform and bring transparency to the process, and impacts. We will also examine other litigation reforms throughout the United States. Finally, we will look ahead to where litigation might be going in the near future. In fact, I'm at a conference today and we discussed third-party litigation funding. Our wonderful presenter today is Michael Farley, CPCU, VP Government Affairs and General Counsel for the Ohio Insurance Institute. He leads the association's legislative and regulatory affairs initiatives. He represents the industry before executive, legislative, and judicial branches on public policy and regulatory matters, and serves as in-house legal counsel. Prior to joining the Institute, Michael was Judicial and Legislative Affairs Counsel at the Supreme Court of Ohio. He also served as Assistant Director for Legislative Affairs at the Ohio Department of Insurance. He holds 2 law degrees from Capital University Law School, an LLM in Business Law, and a Juris Doctor. He also received a Master of Public Administration from Ohio University and an undergraduate degree from the University of Akron. He's admitted to practice law in Ohio and the District of Columbia. He serves as an adjunct professor of law at Capital University Law School. Michael welcomes your questions on the presentation. Please enter them in the chat or Q&A. Michael, take it away.
Okay, well, thank you, everybody. Sue, thank you very much for the warm introduction. And Jan and the team from MSO. We here at the OII appreciate our long-term partnership with MSO and Jan and her team. We are the Property Casualty Trade Association here in Ohio. We like to think we're amongst the best in the country because Ohio's market has been very competitive and robust over the last many years. I am Michael Farley. I'll be speaking a little bit today about third-party litigation funding. That's going to take up the bulk of our conversation. We'll talk about some new trends we're seeing in the space, and as time permits at the end, we will gladly look at some of those new trends that are coming forward. Now, I cannot see the chat, and I guess that will be. Oh, there we go. I'll leave it right there. Okay. Technology is never my friend, but I am Michael Farley, and she did a really nice introduction, so we'll skip ahead and really get into this really long, verbose definition of what third-party litigation funding is. And I leave it up there like this because smart people wrote it, and we want to give them credit. The U.S. Chamber ILR has done a lot of work around this, and so has ATRA, the American Tort Reform Association. for the last 10 years, we've seen this evolving wave. It started out as a trickle, then it kind of started moving up, and we always thought it was like big class action things and mass tort cases. And then I started talking to my claims attorneys doing the $25,000 auto suit, and they're like, I don't understand why this isn't settling. It's policy limits. Why are we not settling? And then we started discovering, after the fact, talking to our insureds, that indeed we did have third-party litigation funding in process. So what is it? It's the process where third-party funders provide money to a plaintiff or a plaintiff's counsel in exchange for a cut of the proceeds resulting from the underlying litigation or settlement. They sometimes involve a funding agreement that contains the funder's identity, investment amount, payment schedule, and whether the funder may exercise any strategic control over the litigation. The interesting component to all this is that we've seen some of these, but they're hidden. And this lies in the shadow underworld of litigation, is because these are not currently routinely disclosed in most jurisdictions. We're trying to change that, and actually you'll see some of our solutions moving forward today. One of the key components to third-party litigation funding that rarely finds its way into definitions is that it's non-recourse. So that means if, to borrow the bad expression, if the plaintiff doesn't get paid, the third-party lender doesn't get paid. That makes it takes a lot of risk and decision-making away from the plaintiff, because they don't have to worry. You know, it's not like a loan where I have to pay it back regardless, or a traditional recourse type of loan. It's non-recourse, and we see that these are moving forward. So there's two kinds of groupings, and some of this is going to sound really elementary, but we're building blocks into kind of a crescendo, if you will. There are consumer loans and there are commercial loans. The consumer loans, I never want to put a dollar amount around these. Well, they're probably less than $1 million. They're more likely they're definitively less than $1 million. They're probably less than $500,000. I'm looking at, my 250, 500, auto insurance here in Ohio. That's probably the upper end of where these consumer loans go into. They're not always uninsured interest, but I think reality means that if you're in a car accident, that's where these consumer things are popping up. Ohio is a monopolistic state for workers' comp, so we don't see a lot of workers' comp type cases that come through here. I am told that in other states that are open states that they are starting to see some third-party litigation funding come into some of the workers' comp space. But these are lower dollar amounts, traditionally pretty simplistic. And we're going to have an example of one that went before the Supreme Court of Ohio a number of years ago before we knew what was coming. The commercial ones are the ones that you hear the chamber and the national trade associations and ATRA. Those are the ones they're talking about most of the time. And those are the big ones. They're dealing with mass tort actions, mostly, not exclusively, but mostly those are going to be your class action litigation pieces where there's big bucks, not a lot of recovery in place. And in most states, we still allow lead plaintiffs to collect the proceeds on third-party litigation funding and not have to show them pro rata. That will not change, and it's not something that I'm going to advance because I can lift a lot, but that's a lot of lifting to get that, of course. These commercial loans are often $1 million plus. They have the actual agreements we've seen are like a traditional lending agreement that you would see, like 60 to 100 pages, and we're not. There's a lot of minutia involved in those. So those are the two types. Think of consumers as really what they are. They're mom and pop involved in an auto accident, maybe some kind of other tortious activity that they believe that they have a legitimate claim for, but nonetheless not big dollars. And commercial, usually corporation on corporation or large class action. Third-party litigation funding started in the mid-90s in Australia. If you really want to go down a nerd hole, most of you will know that Australia, like the U.S., kind of falls from that UK tradition of law, the British system of law. And there's when you start something like TPEL, in a British series of British style law, it's only going to go a couple of places initially. It's going to go to the U.S. and it's going to go to the U.K. And that's what happened. UK, so many massive funders like Burford and others are headquartered in England, London particularly, and it all started in Australia. It's now an industry that is estimated to exceed $15 billion in commercial litigation investments just in the United States. And this is another a story of warning, is that we really don't know because it's not disclosed. It lives in the shadows, and it's something we guess based on what we've seen and what we've seen settled. Notice that there's a huge caveat here with commercial. I'll highlight it. Oh, oops. That was bound to happen. With commercial litigation, that's a little easier because we've seen more of those agreements. We've seen very few of the consumer agreements that are in play. And this is just the United States. These are taking off all over the world. So this is the case. This is the Ransman versus State Farm case I referenced earlier. This was before the Supreme Court about 20 years ago, maybe a little over 20 years ago, early 2000s. There was a car accident. The plaintiff entered into a third-party litigation funding agreement, a non-recourse third-party litigation funding agreement. The terms, and I love showing these terms because it kind of really shows, and this is one of the few consumer agreements we had for a long time, is that look how egregious these terms are. So the plaintiff was advanced $6,000 for the first $16,800 if settled within the first 12 months. It then goes $22,200 on your back number. So it's still $6,000 for that. It gets better for time, right? 27 within 27.6 after 24 months. But if rankment or ransman, I've really never gotten the official pronunciation on that, lost, nothing will be repaid because it's non-recourse. Then a couple of months later, another $1,000 was popped on, but that's for the next $2,800. So think about that. That's a 2.8, times return. And up here, it's about what? It's about 2.8 times, right? It's almost 3 times. Those are pretty good numbers if you're a third-party litigation funder, if you win. And I understand, being an insurance guy, I also understand that there's risk imparted here, and they're trying to recover those dollars. So within 12 months, the case settled for $100,000. One of the things that doesn't get mentioned, and I've fallen into the trap I usually excoriate, is we forget that most of these are falling under a contingent legal agreement where you'll see something along the lines of 33%. Usually in Ohio, it's getting around 40% if something goes to trial. So let's just say 40% because I went to law school not to do math, and that's $40,000 right off the top. And if we go back one, we'll see within 12 months, that means she has to give him 6. That's $46,000 off 100. Now that's tax free, right? There's they don't pay tax on that. So she had only received. Oh no, I'm sorry. She only received $54,000. Well, somebody talked to Ransman, I believe it was a female, and they said, that sounds ridiculous. Why would you do that? So instead of following the third-party litigation funding agreement, the plaintiff returned all of the funds advanced and included an 8% interest. And the 8% was used because that's statutory interest. Then the plaintiff filed ostensibly a declaratory judgment action for rescission. And I think the trial court granted the rescission, the appellate court flipped, and then the Supreme Court said a contract making the repayment of funds advanced to a party to a pending case contingent upon the outcome of this case is void as champerty and maintenance. And now, I'm not expecting that all the lawyers on here paid attention in property class first year of law school, I know Jan and I were talking about the first year of law school, and I struggle to remember a lot of those fishes and whales, let alone Champerty and maintenance. But this is an ancient notion of property law, and I think the different presentation. I actually defined what Champerty and maintenance were, but basically say you can't. It is improper under the public policy considerations to have a control in litigation. A third party should not have control of litigation. So they actually accepted the void. And you're thinking, Michael, if this is the Supreme Court of Ohio saying this, why are you so exercised? And one of the national crybabies, as one of the third party litigation funding lobbyists called me, one of the national crybabies on third party litigation funding. It's because the General Assembly passed a statute a couple of years later, a very loose statute that permits third party litigation funding in Ohio. And it was, of course, the sob story of the mom who couldn't pay a gas bill because she was in a car accident. I don't understand that if there's not major injury involved, because we also, those of you who have an insurance policy, we advance medical costs, most of them. And we also have other things that are coming in the door. So anyway, that's a different argument for a different day, but they did change it. So next, we'll talk about the varieties. So we had, consumer and commercial, and the two varieties we're seeing are the consumers, the plaintiffs, and that's what we just talked about in the Supreme Court of Ohio case. But we're also looking at the attorneys who get funded. Now, I really want to, the consumers and the plaintiff side of this is pretty easy, right? Those are pretty straightaway third-party litigation funding agreements. They're entering into them. In Ohio, the attorney who's involved with the case has to look and sign off, so they have notice. Which brings up one of my great arguments: is I have no idea why I have to fight the trial lawyers on this. You would think the trial lawyers would be walking arm in arm with us, because these cases do not settle because somebody has entered into this egregious upfront third-party litigation funding where they're not getting paid until there's settlement that's well beyond anything that any of my members would ever offer. So now they're going to trial, which will cost everybody more, including, by the way, that contingent lawyer who's only going to get paid if there's victory or settlement. And yes, it goes generally from a 33 to a 35 or 33 to a 40, depending on the situation percentage. But some, if you go to court, it's 50-50, and they're losing some of these. So I don't understand why plaintiffs' attorneys have not joined arm in arm with the business community on this, because they're getting hurt too. It usually doesn't bother me, but here I think it's emblematic of a problem. Now with attorneys, this is where people get sometimes confused. The attorneys are going to have lines of credit, and if you've read a John Grisham novel, you know that they have endless amount. Either one of two ways. There's novels that have endless amounts of bank loans that can come in, or it's the small town lawyer who has to mortgage his or her house to pay for the litigation expenses and living expenses because this is their big case. Those are not touched by any third-party litigation funding aspect. What we are seeing as attorneys, our attorneys, who are entering into their own third-party litigation funding, it's very, very, very sketchy on the legal ethics, because we as attorneys are not supposed to let third parties guide the litigation strategy. Inherently, when there's another funder at the table that's not a recourse lender, you have a different vested interest that you've let in the door. I'm aware of only one jurisdiction that allows non-attorneys to share in profits with lawyers. Most have a very clear rule off the model rules. The jurisdiction I'm actually licensed in is DC. DC allows non-attorneys to participate in the profits of a law firm with partners and actual attorneys. And a lot of that's because of the lobbying that goes on in DC. You have law firms that are mixed in with lobbying firms and law firms. But this ethical problem is because these are silent, quiet, in the lurches, in the dark. Those aren't coming forward. I imagine at some point, some plaintiff is going to be mad at their attorney and they're going to sue them, alleging malpractice And that's usually, I think that is when they'll all stampede to our side on this, is when a couple of good malpractice cases are brought, because that is how, through discovery, that is how these, on the attorney side, will be brought forward. On the plaintiff side, again, those are also very quiet, not disclosed. I think those will be more amenable to statutory changes that are being proposed across the country. The problems, as you might expect, some of these third-party litigation funding agreements, the TPL writ large has become a lottery ticket. They're betting against settlement and for lengthy, expensive litigation. I don't, most of the folks on this presentation are aware that there's two major duties. There's a duty to defend, and there's a duty to indemnify. The duty to defend in most jurisdictions is going to be much broader than the duty to indemnify. So we're stuck in these litigation vortexes as insurers for a great amount of time, when normal settlement would have occurred, because we've reached, inside of our duty of good faith, we've reached, what we think a settlement should be. We've proposed it, and it's been rejected out of hand. But the thought is, for the third party, is if we stay in and we get one of these juries, which we're starting to have more jury problems again. We kind of abated those in the 2000s and up to probably 2015, 2016. But we're starting to see the rise of runaway juries again. So now it behooves the lenders to come out and say, sure, hang in as long as you can. We might get a jury verdict that should have been the $100,000 of settlement, which really is going to be about $400,000, because the jury got really, fell in love with the plaintiff, or whatever causal relationship might have been there. Of course, these higher litigation expenses do ultimately lead to higher prices for companies, but also higher premiums. This is a significant driver today in commercial auto. We're seeing a lot of our commercial auto are directly correlated to litigation expenses. I don't want to mitigate the property loss side of this. There is no such thing as a $50 bumper cover anymore. Commercial auto still sees the same inflationary pressures that personal line sees, but we're seeing, because of the policy limits, because of who's driving, and the tortious environment we're in, that those commercial vehicles are seeing higher litigation expenses. We suppose that a lot of this, or at least a good portion of this, is due to third-party litigation funding agreements and our inability to reach settlement. One of the antecedent issues is when we can't reach this higher litigation expense. I'm in Franklin County, which is Columbus, Ohio. We're one of the fastest growing cities in the country. We are the largest city in Ohio. We have what we lovingly call the rocket docket in the Common Pleas Court, our court of general jurisdiction. If I were to file a case today, it used to be 1 year. It's already moved to 13 months. You're given a trial date 13 months out. Very rarely do you get your trial date 13 months out. Our trial division in the Common Pleas is both criminal and civil. Criminal, because of the constitutional issues and speedy trial requirements, take heed, and civil goes to the back of the door. So for the longer we stretch this out, the more the plaintiff thinks they should be getting, which is normal. It's always been that way. Now you have a third-party litigation funder sitting there thinking, okay, you're going to give me this much on this much time, this much on this much time, and this much on this much time, as we saw in the previous example. A lot of pressures come into this. And we're also seeing that trials are not happening as quickly as they should be in most jurisdictions across the country. And we're also seeing people chase, which is a whole different issue we can talk about later. One of these look ahead to the future is people are chasing venue more now than ever. In Ohio, we know that they can run to Columbus, Cincinnati, Cleveland. If they can find any nexus, we've had car accidents way out the Pennsylvania border, somehow find nexus to get venue in Columbus, and they litigate in Columbus, whereas you might get a little more insurance-friendly jury if you're out in a more rural area. We're seeing a lot higher verdicts in the three C's, as we call them, Columbus, Cincinnati, and Cleveland, because of that. This raises a significant ethical issue as well. Should folks not a party to the case exercise influence over a case in such a meaningful way? Not only does it raise those very meaningful ethical issues, but it goes into that Ransman decision we talked about earlier, when it said that's not supposed to happen. Probably the shortest slide you'll see today, but the potential policy solutions. We have been doing a lot of work inside of our Ohio Alliance for Civil Justice. It's a broad-based business coalition who formed in the 80s to, I'm sure Jan will remember some of these days where the tort environment in Ohio was not quite as friendly as it is today. We had the Gang of Four on the Supreme Court making up policy provisions on the fly. But this group has come together, and we were one of the early adopters of this is a problem, but subsequently we're because of a lot of dynamics, including more plaintiffs bar attorneys are Republicans than it used to be. It used to be the Republican was the party of tort reform. Now the plaintiffs bar is because of probably the shift in partisan alignments more than anything. We're seeing this dynamic all across the country, but also just more of a populist appeal. Tort reform is not as easy as it was in the beginning of my career. We passed the major overhauls of tort in Ohio. But what we kind of settled on is we still don't know what the problem is. We know it's a problem. So we've really pushed for disclosure. Ideally, pre-suit disclosure is primo. Because that most, 85% of these things are going to settle before they go to jury trial anyway, probably 90%. So if we can get those information without, we base this on 26 Civil Rule 26B, which is in Ohio 26B. I think other states fashion a little bit different. The federal rules have the same provision, but as many of you know, an insurance policy is automatically disclosed. And in the policy rationale, we're going back in the 70s when the federal analog was passed, and Ohio passed our analog. There's a staff note, and the staff note says the reason we want insurance policies to be disclosed is that it helps us value a case so we can go forward with settlement. It says that in the staff notes. The same principle applies for third-party litigation funding. So we've been working pretty nonstop with the General Assembly, trying to get them to do some level of disclosure. I don't have any cases in the pipeline that I'm aware of where a third-party litigation funding has been, like we'll talk about in a minute, it's happened in Delaware and other jurisdictions where, you have a case and I can take it to the Supreme Court and have them be the final arbiter. Based on the language of Ransman being precedential in Ohio, I think I would have a pretty good outcome, which is probably why we're not getting those cases yet either. But to quote the former Supreme Court Justice Louis Brandeis, sunlight is said to be the best disinfectant. The more exposure we can get on these, it will give us more idea of what's actually going into these third-party litigation funding. It'll help, candidly. We're going to be able to train our trial counsel, both inside and outside. We're going to be able to train them better to come up with settlements that meet the needs of all parties in this. It's going to let us evaluate cases better, which is exactly what the staff note said we were looking to do with insurance policies. But it's also going to, give that public policy ramification of letting people know who's actually involved in this litigation. The silent hand in the litigation doesn't promote judicial economy. It doesn't promote access to the judiciary, or that fundamental fairness when you see the balancing, Lady Justice out there with the balance. It doesn't necessarily tip that way. Right now, it's tipped heavily in favor of the plaintiff's bar in most jurisdictions, with a couple of exceptions we'll talk about shortly. So we'll probably talk a little bit more about third-party litigation funding in a little bit. One of the things that's actually happening now is we're trying to get, we're seeing a degradation of the jury process of a trial. When you represent, I always have to remind folks, I represent insurance companies. We think we're great. We think we're doing great things for great people. But that's not always the public perception. Particularly in times now, we have increased premium being charged. We're seeing inflation cause problems with how long it's and availability for how long it takes to replace vehicles. I'm very proud of my members for how fast they're adapting in these spaces, but it's not always to the expectation of the consumer. And when we walk in and we're defending someone or there's an insurance policy at play, people don't understand insurance policies. They used to bother me. Now I just view it as job security. But people don't read their policies. They don't understand. Roofs are changing and all these policies around. My members. Some are requiring higher deductibles. Some are just not covering of a certain age. But that's because roofs are expensive and people don't maintain their roofs. And climate change being what it is we're seeing our friend Cassidy in the path of a storm. One of the responses to this at the federal level, this actually started federal. A lot of these will start local, move federal, but this started on the federal level. And some of you may be aware of and familiar with the "Don't Say Daubert" concept that or the campaign that went around for a number of years. Trial courts were always after Daubert. They were supposed to take, judges were supposed to take control of were these expert witnesses actually experts? That fell apart in many jurisdictions, particularly in the federal courts. You had certain jurisdictions who were good at it, others weren't. So there was a movement afoot to go to the Commission on the Rules of Practice and Procedure at the federal level and have them amend Evidence Rule 702. And that's, of course, the expert witness rule. This rule is heavily used. If you try to shepherdize it in your LexisNexis, it takes a minute or two to come up with all the cases. But it's the qualification of expert witnesses. The courts are involved. We're trying to keep the courts involved in determining that the testimony meets the level of expertise. For example, you have an economist who comes in and says, this is a real life example. We had this in Ohio. Horrible fact pattern. Young lady was killed involved on I-70, which goes through Columbus, but it was not in Franklin County. But she was killed by an 18-wheeler truck, big truck. And the driver clearly negligent for that to have occurred. Driver of the truck. The witness for the plaintiff came in, was an economist, but not experienced in determining future earnings. Was an economist who taught European economic theory, but was nonetheless qualified as an expert in this court because candidly the judge didn't know any better. And they said that this young lady who with no prejudice to this at all, but she had a GED, was working at McDonald's part-time, and they calculated a future earning number of somewhere between $7 and $10 million. I don't know math. The math doesn't math for me, but it did for the trial judge because he said, the trial judge in error said, I'm not supposed to get involved here. That's a fact, finding of fact. Well, no, that's a finding of law because he didn't qualify the expert properly. And then, so that's the first qualifying the expert. And then saying after the fact, hey, that's complete baloney. The judge needs to come back in and either order additional briefing or allow rebuttal testimony on that to make sure that not only is the expert qualified, but is the opinion appropriate based on where the witness is. The young lady's family was compensated in lieu of an appeal, which I think plaintiff's counsel knew they were going to lose. The settlement was reached. It was not $5 to $7 million. We're trying. So the federal rule went into force last December, December of 23. Ohio was one of the first jurisdictions. Once we saw this, we thought this is a great way to promote trial reform in Ohio, to get those expert witnesses in, because we're seeing that these expert witnesses were allowing and helping and abetting rather the plaintiff's party get these unrealistic jury awards. And we do have non-economic damage caps in Ohio. And, you know, a lot of these go to punitives, right? At least they do in Ohio, and a lot of the federal courts using Ohio law. So this has been, we haven't seen it, it's starting to manifest a little bit in Ohio. I have been told as recently as last week that we had a case settle on a very similar fact pattern with the truck. I think it's no surprise to anybody on this presentation and my friends at MSO that these trucks are, you know, this is where the money's being made in the plaintiff's bar, because most of the time they have a $750,000 or $1 million policy, as opposed to my minimum limit policies in Ohio, which are $2,550. So we have a very similar fact pattern. The judge held that the expert witness was an expert, but said that the opinion did not meet the level of expertise that they were in for. And so they had to go back to the drawing board. And when they went back to the drawing board, they went back and said, instead of going back and hiring another expert, let's settle. And the settlement helps because instead of waiting for a 2-month trial, those folks got the money that they were entitled to much earlier, which evokes my insurance companies love to pay people. We love to pay people what they're actually owed and when they're owed it. I tell people that a lot. So this gatekeeper function has already paid dividends in some cases. We see a case in New Jersey. It's a very big case. If you Google this case, you'll see a lot of Wall Street Journal, a lot of business, because this is the Johnson & Johnson talcum powder litigation. This was going through the federal courts as I think it was multi-district litigation, but definitively in the New Jersey courts. And the judge allowed for questions on sufficiency of an expert's basis as to admissibility. So when those questions came about, instead of having, and I didn't write down the number, a multi-billion-dollar judgment, or I think it was multi-$100-million judgment in force, the judge threw out the number on this basis. And I think the appellate court is who threw it out for, you know, if you're looking at procedural posture. The appellate court threw it at the Supreme Court. It was the Supreme Court. Was it the Court of Appeals? I think it was the Court of Appeals. Threw it out based on a 702 application using the federal rules of 702. That's significant because that's when we have expert witnesses, they're supposed to be indeed an expert, and they're supposed to purport expert witness based on their own expertise, not on subjective findings that are not based in fact, science, or rigorous analysis. That doesn't see, I mean, you know, my litigation buddies really are happy that I got evidence rule 702 fixed in Ohio, even though it wasn't a major problem in Ohio. It was a little bit of a problem. We started seeing it bubbling. So under amended FRE 702, 1, a court may not admit expert testimony unless the proponent establishes its admissibility by a preponderance of the evidence. So again, we're putting the burden back on the plaintiff, not on the defense, as it was trying to shift to. And a court must find that an expert's opinion followed from a reliable application of the methodology to the facts at issue before that opinion is heard by a jury. Now, this doesn't mean that the judges are all of a sudden going to end up being, you know, Bill the Science Guy. And some of these, they're not going to, but they're going to require additional expository testimony and perhaps briefing to find out, is this an actual reliable application of the methodology? It allows the defense to come back and say, this is not a reliable application of the methodology. Anytime you have a discrete, and I'm not a litigator, I'm not smart enough to be a litigator, but anytime you have a very a focused area by which to attack, my litigator buddies tell me that that's the ideal place to be in a litigation posture. So those are the two basic components of the federal rule. The federal rule is getting used all over the country right now. I didn't have any. I would love to take credit for the federal rule. It was some folks at ATRA, American Tort Reform Association, were heavily involved in that endeavor, and I do a lot with ATRA. They do a phenomenal work. So because we love to imitate each other as often as we can, I actually sent a letter to the Supreme Court, the Ohio Commission on the Rules of Practice and Procedure, who was tasked with the initial round of amendments. And the Ohio amended our Ohio Evidence Rule 702 to comport with those federal changes. If you're a nerd, you pull it up and you're like, wow, this doesn't track exactly. We didn't do we missed one of the updates in the early 2000s. So we had to skip around, but it's still substantially conforms to that. And those have been effective since July 1. I've only had a handful of folks tell me that they have had cases. It is interesting because we are seeing a lot of cases come out of the Court of Appeals where people, when you change a rule, they like to focus on, when's this effective? Is it procedural or is it substantive and those things? So we're seeing a lot of appellate decisions refer to former rule of Ohio Evidence 702, but they're applying the standard as it existed under case law in Ohio. So we're not seeing the negative effect that I was somewhat fearful of. We're seeing them apply a good rule. Now it's a perfect rule. It was a good rule before, but the federal rule did a lot of work. So I've been doing public policy work now for a better part of 25 years. And it's, I don't know how someone so young and vigorous as I am could be doing anything for 25 years, but one of the things that we're seeing, we used to call them shotgun lawsuits, where you'd walk in, and this is a vestige of the 80s and the 90s, where people would walk in and just name everybody who ever breathes in the vicinity of a tort. Courts kind of reined those in through various tort reform mechanisms, and it became, the plaintiffs' bar realized that it's kind of expensive to name everybody because we're doing this on contingency basis, and we might get lucky and get an extra person who has a policy attached that'll indemnify, but those are becoming less and less proper. One of the final areas we're seeing this remain is not the final. There's a handful of spots, but this is probably the biggest one, is asbestos overnaming. And I don't want to say that Cuyahoga County is like St. Louis or Philadelphia. Those are established judicial hellholes as trademarked and deemed by my friends Tiger Joyce and the gang at ATRA, but American Tort Reform Association. But Cuyahoga County is very close, particularly on these mass tort issues. Cuyahoga County Common Pleas Court has more asbestos claims than almost any court, but I think 4 in the country. And it makes sense. We have a port up in Cleveland. We had a lot of sea bearing that had a lot of asbestos in it. We have a lot of manufacturing plants in Cleveland. We have one heck of a baseball team in Cleveland, not so much football. I'm a fan of both, unfortunately. But these all lead to these asbestos litigation that when people get mesothelioma later on, they need to go back and recreate their steps. What the plaintiffs' bar started doing was having a list, and we found, we've done the research. It's the same list of about 100 plaintiffs. I used to job hop a lot when I was younger, but I don't think I've had 100 jobs. But so they would sue 100 plaintiffs. So what do you have to do as an insurer? You have to jump in there and find out, is it, do the investigation, do we have a duty to defend? We most likely will in that situation. We have found that it costs about anywhere from $20,000 to $25,000 to defend those cases, when we otherwise probably wouldn't be in the business of indemnifying. So it gets really expensive really, really fast. So we've been working a hell of a lot longer than we thought we would. It's been about 6 years, about 5 years now, to get a version of Senate Bill 63. Other jurisdictions, I think, like Utah, Nebraska, Arizona, and other states have passed similar statutes. But we're just trying to prevent the overnaming and make sure they have a factual basis for naming the parties. And it's Ohio's a notice pleading state. We just wanted to come in with a little bit of particularity as to why those parties should be named. Because we see the same parties. We've seen some minor parties be, they're already hanging on by a thread because they're a manufacturer in a world of globalization, and then they get tagged with 40 suits. And these people never even worked within a block of these places. So we're trying to get legislation passed in Ohio. There's several other jurisdictions around the country. But the reason I bring it up in this context is it goes back to the old shotgun lawsuit. I think plaintiffs, particularly in states like Ohio that have strong non-economic damage caps, they are trying to find ways to get creative and bring suits that otherwise wouldn't be meritorious. And if you can get a little brake shop or a welding center that used asbestos in the filament, maybe they settle out for 10 grand real quick. You get your 4 grand, your family gets 6, and you can still keep going after the main plaintiffs. I think it's a little bit dishonest. I think there's some ethical breaches they're doing, and it's a shame that the court, the dedicated docket, Cuyahoga County allows them to do that. But the nice thing about being an old guy as a lobbyist is all the stuff I saw growing up are now coming back again. So at least I remember the concepts, and so do the plaintiffs' bars around the country. One of the things we're seeing in this new, and this is kind of and I disagree. We're actually going to address Jan's question in the chat. So they're expert witness bureaus, almost like speaker bureaus, paying a lot of money for an expert. How can these costs be controlled in the litigation? I think inherently when we're going to qualify these folks, we're going to do. I mean, the plaintiffs and our we have the same duty, but we usually meet our duty. I think you're going to see a lot of insurers be very careful in how they're qualifying those experts before they hire them, and that's one way of controlling cost. And I think experts are going to be used not as widely as they were before. There's still plenty of business out there. I do some expert witness questioning work myself, but I think that one of the ways they're going to control the cost in those is to make sure before they're hired that they're qualified, and that the judge will subsequently agree with them. I think now the plaintiff's bar is like, oh, you're an economist. That's enough. Come on in. And before that, particularly in Ohio courts, that slid. Federal courts, it was sliding too in many cases. Yeah, there are. So the other question is, I heard there is a move to pass legislation to tax the payments for TPILF upon settlement. That's not something we're looking at in Ohio. But I do know that there are states that are looking to assess a tax payment. It's a little bit tricky because the federal, you have to do a very specific statute. The federal tax code exempts settlements, and then if you have a settlement or an award from a court from taxation. So it has to be done very carefully. But I do know there are states that are looking to do that as a way of curbing it on the back end. I don't think we could do that in Ohio very easily. Great questions. So as we're looking at some of the future things that are about to be happening, look into the dark future. I always feel like it's such a negative conversation when you talk about tort reform, but it is what it is. The American Law Institute, the ALI, for those of you who are lawyers, is the second restatement of torts, and they had a really strong tradition going back to when Chief Justice and President Taft helped found them in the 1920s. They've really drifted away from the restating of what the law is to more of an aspirational what we wish it is. And we saw that most acutely in the restatement of law, liability of the law and liability of insurance when they issued that. And I think they issued that, it's been a couple of years ago. It's probably about 6 years ago. And so states are starting to take action against those. This was something Ohio did. And I think we did it. I wrote it, so I'll be I'm a little bit biased. We did it very bluntly. We used a very big knife, and we didn't leave any edges around. This tells that courts are not to use the ALI as law, and it comes off a very strong theory, right? This is a tap out to usurping legislative authority by allowing a third party to write the law. At least that was the argument we used, and it worked. It's telling courts that this is not the law of Ohio. Why is that important? Well, that's important because one of the things in the restatement of law, liability, and insurance is the reasonable expectations doctrine. And that usually makes insurance lawyers quiver, scream, and cry. We're all on mute, so I can't hear you cry. But it makes us cry too. And one of the things that this would have done is if we would have had some activist judge in Cuyahoga County or on the Supreme Court pick up that and say, oh, look, this is the restatement of the law. By saying that this is not the law, we don't have to worry about that in Ohio. And actually, we've actually helped argue the opposite, that because of this statute, 390182, the legislature has directly said they don't want the reasonable expectations doctrine. So, you know, there's other ones like the restatement of consumer contracts that's out there. It's a hot mess as well. I know we're coming up on probably 3 minutes left here. I want to just hit a couple things on the way out the door. Nuclear verdicts. These are and they're very common with the jury, runaway juries. And that is also I think it's a John Grisham novel too. But nuclear verdicts, these are where it should be about a $500 million judgment, but because the victim was, a cute, adorable, 25-year-old man with his future in front of him, very personable, for reasons that are not legal, the jury came out and said, sure, we're going to give you $5 million. Those are interesting because punitive damages by statute in Ohio, most states have a similar statute, aren't covered under auto insurance policies or any insurance policy. They're verboten, but it's really hitting the business community in a big way too, and to the extent we have them. And I think these runaway, we're seeing commercial auto policies are really getting hit, and because of all this, you kind of give fuel to the third-party litigation funding. Because if the more cases that are out there, the bigger judgments, the more the third-party litigation funders are in. Something we're about to see happen in Ohio, we have some cases moving through Franklin County on medical malpractice. It's starting to see significant strains because they're trying to, because med mal attorneys, we have caps in Ohio, we have pretty good case law around it. They're trying to do some collateral attacks on it, and they're doing it in other states too. But third-party litigation funding hits it, nuclear verdicts hit it, runaway juries, social inflation, and you just keep repeating that cycle. And if you hear a loud cheer from Ohio in the next couple of months, it's because the Supreme Court of Ohio took an invitation from the business community to abolish public nuisance claims. We've seen them in opiates, lead paints, and those forever chemicals. There's not a tradition of those under Ohio law, and other Midwest states have similar case law. You saw Oklahoma come down with a very similar ruling that there's no such thing as a public nuisance of opiates. We already have case law in Ohio that says insurance policies don't respond to public nuisance claims. This is just going to get rid of them writ large forever, because I have to litigate each and every one of these. I have to go to court and say, yes, we don't have to respond to opiates, so the duty to defense doesn't attach. Then the lead paint, then the forever. So this will get rid of it, hopefully, once and for all. So just as as we wrap up in the last minute here, solutions or mitigations, you got to pay attention to judicial races and appointments. Every state's a little bit different how they do it. You got to watch the judicial decisions, and I say watch them at an earlier phase. Watch legislation. One line is what happened to us in Ohio of third-party litigation funding. It was already forbidden under case law. We let it go in a little bit, and now it's being abused. And I would say stay engaged. MSO puts on a lot of great educational material, and other entities do as well. So stay engaged, and if anything I can do to be of help, feel free to reach out.
So can I?
Thank you, Michael. Yeah, Jana, do you have any comments?
Yeah, well, I first want to say thank you. I know Michael for a while, and I'm from Ohio originally, so we share a couple alma maters there, Ohio University, and I spent some time at Capital Law School. So really appreciate you getting on and doing this today. That is terrific and very, very timely. All that you talked about, and it's a hot area right now for sure. So thank you. And Sue, you want to continue, but thank you.
Thank you, everyone, for attending today. Our upcoming schedule, our own Mary Beagle will offer an update on trends in the BOP on December 10th. As I mentioned before, the Ed Seminar will be held virtually on November 12th and 13th. The topics are agritourism with Rich Polkowski from MSO, ensuring your online home business with somebody named Sue Quimby, claims trends from a legal perspective with Justin White of Hesta and White, PA, and responsible use of generative AI with Kritika Bharadwaj of Day Pitney. So in 2025, we plan to focus on offering 3 CE webinars in addition to the 4 hours offered at the Ed Seminars. Proposed topics include farm, cannabis, and DNO. contact us with your suggestions for future topics and presenters. These all are being recorded, so this you'll be able to access this again on demand on our website. Information on all of our programs is available on our website, msmnet.com. We have over 200 articles that are available for your use. We've been busy expanding our continuing education school nationwide. So if you were in a state that you'd like CE for in one of our upcoming programs, please let me know. Once again, we would like to thank all of our sponsors, and thank you, Michael, and everyone for attending. Special thanks to our team who makes this all possible. And please complete the survey that hopefully will appear when you exit the webinar. Are there any final questions? Not? Then thank you all for attending. See you next time.